Hello friends, Namaskaram. Today I am going to discuss an important judgment of Honorable Gujarat High Court concerning Section 7, Section 13(1)(d) of PC Act, and apart from that I will discuss all the elements step by step in systematic manner. So please note down whatever I am going to narrate you, but before noting down be conceptually clear so that you could apply the principle that is going to be avowed by me in your case. Okay now? So first point is that please note down the details of the case. Judgment is pronounced by Honorable Gujarat High Court. Judgment is dated 10th of March 2025. Petition number is 532/2006 and judgment title is Manhar versus State of Gujarat. In the said case there were two accused. Accused number 2 and accused number 1 had been prosecuted under the provisions of Section 7, Section 12, Section 13(1)(d) of PC Act with Section 120B of IPC. Ultimately, accused number 2 had been acquitted, but accused number 1 had been convicted as per Section 7, 13(1)(d) of PC Act. Ultimately, the said judgment had been challenged by accused number 1 before Honorable High Court. Before Honorable High Court, he inter alia put up 15 material points to stand his defense. So, every accused must remember all these points so that he could easily understand what is the basic requirement of prosecution, and if he is prosecuted then how he could defend, and apart from that what are the essential evidences which are required to be required for the prosecution of the accused under Section 7, 13(1)(d) of the PC Act. Friends, as we know that for the prosecution of accused under Section 7, 13(1)(d) of PC Act, demand is sine qua non, and the said principle is recently observed by Honorable Supreme Court in judgment of Dilip Bhai versus State of Gujarat. Judgment date is 27th of February 2025. In that case, it has been observed that even mere allegation of demand cannot be a basis for prosecution. Even though a public servant is charged with allegation, misuse of authority, but the said allegation is without demand, acceptance, recovery of money, in that scenario, no case is made out for the prosecution of accused under Section 7, 13(1)(d) of PC Act. In the said case at hand, the story of prosecution is that the concerned complainant is having the agricultural land. On the said land, the high tension line are to be installed, and the decision had been taken by electricity board. And apart from that, the tree had been cut down and compensation is to be awarded as per order of electricity board. But for doing the same, accused number 2 is required to do the field inspection to record the statement of complainant so that he could submit his report to accused number 1, and accused number 1 on basis of said report could take the further step so that the compensation could be released to the concerned complainant. You got the point now? So accused number 1 is depending on the act of accused number 2. You got the point now? So in that case, the concerned complainant submitted that whenever he inter alia met with accused number 2, on that he told that money is required to be given or part with so that his work of compensation could be done expediently. He demanded money for himself and for accused number 1. And inter alia, the concerned complainant met with accused number 1 who demanded money for himself and for accused number 2, and inter alia, accused number 1 was caught red-handed. Accused number 2 got acquitted, but accused number 1 was convicted under Section 7, 13(1)(d) of PC Act, but he also acquitted from Section 12 and Section 120B of IPC. The primary contention of the concerned accused is that there is no cogent evidence on record to sustain the prosecution. That is point number 2. As we know that for the prosecution of the accused, supporting, sustaining, corroborating evidence must be on record. If the allegations are bald, without any supporting evidences, allegations are not specific, in that scenario, prosecution of the accused would be bad in law. So on that point, the accused had emphasized. Point number 3 is that he submitted that the ingredients of the offense is absent on record. As we know that demand, acceptance, recovery are 3 elements for the successful prosecution of the accused under Section 7, 13(1)(d) of PC Act. So demand, acceptance and recovery is missing. So in that scenario, it could not be said that the concerned accused would be guilty. Point number 4 is that on the same set of evidence, accused number 2 had been acquitted. So the benefit of parity is to be given. He submitted and emphasized on that criteria also. Point number 5, it is that even though there is a presumption of Section 20 of PC Act, but the presumption cannot be drawn on mere submissions. To draw the presumption, primary facts, primary evidence must be on record on the basis of which it could be said that ingredients of the consent PC8 had been infringed. If the said protocol had not been adopted by the concerned prosecution, in that scenario, the prosecution would be bad in law. And apart from that, he emphasized that the said protocol had been duly approved by Honorable Supreme Court in judgment of Neeraj Datta versus State of NCT. In the said case, certain principles of law had been discussed, but few of them are quite important. Point is that the proof of demand is sine qua non. If demand is not proved, the basic elements are not proved. In that scenario, presumption cannot be drawn apparently. And apart from that, the accused shall be deemed to be innocent, and sustaining the case is the bounden duty of the prosecution. If the elements are not proved, weakness of defense cannot be a basis to sustain the prosecution. Okay, na? You got the point. Point number 6 is that the Panchnama is quite important. Specifically, he emphasized that it is a material document. In the present case at hand, the said document had been withheld because said document is necessary for calculation of exactly the compensation amount. So without said document, it is not possible to conclude the compensation to be awarded to concerned complainant. So the primary attack of concerned accused is that if the said document is not on record, that is material document, the said document is basis for calculation of compensation, then in absence of it, how it is possible for complainant or SEB to conclude that the amount is 10,800 towards compensation? So he submitted that the material document had been withheld. Always remember that if a document is relevant and necessary and the document had been concealed by the concerned prosecution, in that scenario, adverse presumption can be drawn against the prosecution. For this, the accused has to put up the straightforward question to the concerned complainant, the concerned TLO, concerned IO, and concerned department officials who is inter alia deposing the testimony concerning the service matter. But on that fact, the question could be asked, don't worry, there might be a restriction that the cross have to be confined to the extent of examination in chief, but BSA means Bharatiya Sakshya Adhiniyam inter alia gave us the authority to ask question even beyond the examination in chief to sustain our defense. So always remember that accused is not required to stand his defense beyond reasonable doubt. He is required to stand his case by the preparedness of the probability. So while doing the same, either he may do the cross-examination at length or he may support the case by putting the evidences in defense. Okay, na? So all this protocol is required to be stand in our mind as well. So next point is that no work of the concerned complainant is pending. So he submitted that accused number 2 had to do the field inspection and then have to submit the report. Then I have to issue the compensatory order. But all the protocol had not been followed. So in that scenario, work of the concerned complainant is not pending with me. So non-pendency of work is also one of the most important criteria to say that there is no motive or grid on my part to demand and to accept the money. Point number 8 is that the complainant in the cross-examination admitted that the accused number 1 had not demanded any money. That is very important. Sometimes there is a usual question from your side that concerned complainant is going to support us. What question is to be asked? So in that scenario, if complainant says and admitted before the concerned court that the concerned accused had not demanded any money, in that scenario we could have the benefit. So testimony is quite important. So in charge sheet, in report, in other scenarios he submitted that demand is made, but in the courtroom he submitted that demand is not made. So the said inconsistency is beneficial for us, and on said count we are having judgment of Honorable Karnataka High Court, that is Mahesh PS versus State of Karnataka. Point number 8 is that the accused had not demanded the amount. He submitted that, and apart from that he submitted that whenever he offered, accused refused, and inter alia note had been put up in his table. So that is very important point. So it is indicating that the concerned currency notes had been grafted. So on theory of grafting we could have the benefit. Next submission, point number 9 is that as we know that in pre-trial proceeding, the use of anthracene powder or use of phenolphthalein powder is explained to the concerned persons, means witnesses, complainants, so that they could understand the beneficial use of concerned chemicals. So in the said case at hand, the concerned use of anthracene powder had not been explained to them, even though the process had not been demonstrated, and even though the proceeding had been done in the anxiety. The same is sustained by the fact that when the concerned witnesses had approached the ACB department, the concerned powder had been applied to the concerned currency note, the process of demonstration had been done, and apart from that the report had been registered in much quicker manner. So in that scenario, it could not be said that the pre-trial proceeding had been done in the prompt manner and in the due course manner. Point number 10 is that It is submitted that the proof of demand is sine qua non. If demand is not proved, in that scenario, the accused could not be prosecuted, as I observed and submitted earlier. The same is supported by judgment of Honorable Supreme Court, that is Neeraj Datta versus State of NCT. And point number 11 is that the key point is that the concerned accused had demanded, but when he has not demanded, there is no supporting evidence regarding the same. And apart from that, there is a categorical admission that he has not demanded. In that scenario, it could not be said that the demand is duly proved by the concerned prosecution. So on point of inconsistency, the defense had taken the benefit from the concerned court. Point number 12 is that the initial demand was made as observed on the report, but to support the initial demand, there is no evidence. Means the place, time, date is missing. So that is important point, because demand must be specific. If demand is uncertain, unspecific, defense could have the benefit. Point number 13 is that the concerned defense submitted that there is a delay in submission of report. As we know that the report must be prompt and without delay. And if there is a delay, it has to be explained. If delay is unexplained, delay is inordinate, in that scenario, defense could have the benefit as observed by Honorable Supreme Court in Caton of Judgment. And point number 14 is that the presence of witnesses during proceeding is also doubtful, because as per admission, complainant was sitting outside. So when he has not taken participation in the proceeding, he is not the eyewitness. So how he could be in a position to depose like eyewitness? So that casts a doubt in the case. And in the last but not least, there is a major contradiction and omissions in the testimonies. Certain witnesses had improved, certain witnesses had omit certain material fact, and apart from that, there is a contradiction in their deposition. So which is so much major, on the basis of which the adverse presumption, adverse inference can be taken against them. So looking into the fact and circumstances, the court inter alia inclined judgment in favor of accused person and declared the same to be acquitted from charges. So on the basis of said discuss, we could conclude that for the prosecution of the accused, demand and acceptance and recovery is sine qua non. And even though the case is made on point of demand, still the demand is required to be proved. Point number 2, mere demand is not sufficient. Demand is required to be supported by specific, sustaining, corroborating evidences, and there must be a reasonable link in the evidences. If there is a breakage, then we could have the benefit. Point number 3 is that there must be pendency of work. If there is no pendency of work, there cannot be any motive. Point number 4, by the virtue of section 20 of PC Act, apparently from inception it could not be said that the accused is guilty. To draw the presumption, the basic element must be on record. In absence of basic element, the concerned accused could have the benefit on board. And apart from that, the admissions of concerned complainant, inconsistency in the testimonies are quite important. On that point, we could stand our case before the court of law. So see you in the next video. Till then, Jai Hind, Jai Bharat.